Right. Okay. So, as we have noticed that war crime has been considered as one of the heinous international criminal activity not only by the Rome Statute but also by other statute which or even international documents, international instruments which had been in existence since the initiation of UN or even before that. Now, here we would like to understand what is the definition of war crime. So, Article 8 of the Rome Statute 2002 very clearly mentions that it is a severe nature of victimization. It also includes plotting, planning, and execution. What is not a war crime? Here we do get to see Article 31 of the Rome Statute, which very clearly mentions the person acts reasonably to defend himself or herself or another person, or in the case of war crimes, property which is essential for the survival of the person, or another person or property which is essential for accomplishing a military mission against an imminent and unlawful use of force in a manner proportionate to the degree of danger to the person or the other person or property protected. So here what it actually it means, the person was involved in a different defensive operation conducted by forces shall not in itself constitute a ground for excluding criminal responsibility under this subparagraph. So, as I mentioned, while we are discussing about war crime, we also need to look for other international instruments which suggested what can be considered as a war and what kinds of sanctions can be given by the international organizations for condemning the war crime. As we do get to see here, according to Chapter 7 of the United Nations Charter, only the Security Council of the UN has a mandate by the international community to apply sanctions. It should be none other than the UN Security Council. And this must be complied with by all the UN members states, which has been stated by Article 2. Now, there are several types of sanctions which we have already discussed, but here again, let me explain. First is economic sanctions. As you get to see here, typically a ban on trade, possibly limited to certain sectors such as armaments or with certain exceptions such as food or medicine. What is the meaning of again economic sanctions? That means if a country is repeatedly behaving in a way that is not expected as a family of nation, especially when it is going for war, then what happens? It must be stopped. But not to forget that UN Charter has very clearly mentioned that we are not going for Third World War. So therefore, it is best to put a softer side, or it is best to put a soft side for condemning war. I'm not saying that, for stopping the war. I'm saying for condemning the war so that the consciousness of the state, let's be a little bit philosophic from the perspective of jurisprudence. So the conscience of the state would be able to understand that war or warlike activity by the state is not expected by the UN or is not expected by the family of nations. Next comes the question of diplomatic sanctions. But again, for economic sanctions, if you want to clearly understand this in a very simple language, it means banning on the trade or banning on any sort of business relationship with the perpetrator or faulty state. Next comes the question of diplomatic sanction. What does it mean? The reduction or removal of the diplomatic ties such as the embassies. This again is a very much significant political sanction whereby you do get to see that the state starts cutting off the ties with the perpetrator state because they do not want to associate with the state that is faltering state, or they do not want to damage their reputation as a peace-loving state. Therefore, they withdraw the diplomatic ties with the faltering state by stating that we are not going to have any sort of diplomatic relationship or, for example, friendly relationship because you are faltering as per the UN understanding, as per the Rome Statute understanding. Next is military sanctions, military intervention. But this is not war as has been defined by Rome Statute. This is not war as has been explained by any other international instrument. What does it mean? When the war starts, there could be kind of unrest in the country, which is basically showing war tendencies and also the country which is being victimized. So therefore, to bring a balance, to neutralize entire thing, UN military intervention may be possible, or the family members of the UN may be providing their forces to go to that particular country and go for military intervention so that it is peacefully resolved. Now, this military sanction is something which is considered as an extreme sanction. That means that when the country is continuously going for the perpetratorship, or when the country is continuously violating the laws, in that case, the military sanction basically is applied, obviously, again with the UN Security Council, or obviously with the understanding of the supporters of the UN. Next comes sports sanction. Again, it might look very mild sanction, but no. Sports sanction means that country will not be invited, that country will not be allowed, or that country will not be participating. There is a ban on participation for any sort of international or domestic sports event. South Africa had gone through these sports sanctions, we already know that, but it very clearly mentions preventing one country's people and teams from competing in international events, say for example Olympics. Okay. Now what happens is that this is something which is very significant sanction because it is not the state which is being sanctioned or which is actually undergoing some sort of punishment, but now it comes down to the people of the state. The same thing basically we do get to see for the economic sanction also. But if we talk about sports sanction, we very clearly understand this sanction is for right to leisure, etc. That is being cut off for citizens or for members of that particular state. Next is sanctions on environment. So here what we get to see, the declaration of the United Nations Conference on the Human Environment, international environmental protection efforts have been increased globally or gradually, whereby the profits for the environment, the profits of the environment, etc., are not provided to the faulty state. The faulty state is also protected from doing any sort of environmental activities that will either hamper or will benefit that particular country's interest. However, at the end, we are again seeing economic sanctions are actually distinguished. It's a just hairline distinction from the trade because these are applied purely from economic perspective, economic reasons, and typically take the form of tariffs or small measures rather than bans on trade. However, in practice, we do get to see the understanding of trade banning and the understanding of economic sanctions go hand in hand. Now, we also do get to see about the war crime, what the Security Council can do, what the Security Council cannot do. Remember one thing, when we are talking about war crimes as an international criminal activity, because it is considered as one of the most dangerous kind of criminal activity because it may have the consequences of violating, destroying all sorts of human rights, all sorts of rights. So here, the Security Council can take action to maintain or restore international peace, security under Chapter 7 of the United Nations Charter. Sanctions measures under Article 41 encompasses a broad range of enforcement options that we did get to see and may not involve the use of the armed force. Let us understand which are the measures, which are the uh, efforts that have been taken by the Security Council. As you do get to see in this slide, since 1966, the Security Council has established 30 sanction regimes in southern Rhodesia, South Africa, as I mentioned, for the sports sanction, the former Yugoslavia, Haiti, Iraq, Angola, Rwanda, Sierra Leone, Somalia, and Eritrea. Now, again for Ethiopia, Liberia, DRC Cote d'Ivoire, Sudan, Lebanon, DPRK, Iran, Libya, Guinea-Bissau, Yemen, South Sudan, and Mali, as well as against ISIL, which is, as we discussed, it was connected with some other countries, and Al Qaeda and the Taliban. Now, the last few words that we just mentioned basically get connected with the terrorism groups or non-state actors' activity for war crime. Here, we do get to see that the sanctions can go for understanding of military intervention, which did happen for Taliban, Al Qaeda. However, again, we do understand that Rome Statute does not say you have to retaliate by the same meaning, that is, again going for war, but you have to go for peaceful resolution of the conflict, which also includes the military intervention for defense. Now, Security Council sanctions have taken a number of different forms in pursuit of variety of goals. The measures have ranged from comprehensive economic and trade sanctions to more targeted measures such as arms embargoes, travel bans, financial or commodity restrictions. Security Council has also applied sanctions to support peaceful transitions, deter non-constitutional changes, constrain terrorism, protection of human rights, and promote non-proliferation. Sanctions again do not operate, succeed, or fail in a vacuum. The measures are most effective at maintaining or restoring international peace and security when applied as part of a comprehensive strategy and encompassing peacekeeping, peace building, peacemaking. Now, contrary to the assumptions that sanctions are punitive, that means it is for the punishment, many regimes are designed to support governments and regions working towards peaceful transition. Libyan and Guinea-Bissau sanctions regimes all exemplify this approach. Now comes the question of United Nations War Crimes Commission. As we all know, Rome Statute was created in 2002. Therefore, some war crimes could not be handled, could not be managed by the International Criminal Court. Therefore, at that time, it was the United Nations War Crimes Commission that had handled, managed such kinds of war crimes or such kinds of terror-related war crimes. So the United Nations War Crimes Commission, initially called the United Nations Commission for the Investigation of War Crime, was a commission of the United Nations that investigated allegations of war crimes committed by Nazi Germany and other Axis powers in the World War. When did it happen? It did not happen during this 2002, 2003 or 2004, but it happened during the 1949, 1948 time. That means when the International Criminal Court was not created. Again, for such kinds of war crimes, it was a United Nations Commission for the Investigation of the War Crimes which took up the duty of investigation. The Commission's objects and powers were conferred as it should investigate and record the evidence of war crimes, identifying where possible the individual responsibilities. It should report to the governments concerned cases in which it appeared that adequate evidence might be expected to be forthcoming. Very clearly and very carefully, if you look at the first objective, it is actually not stating that its objective is to find out whether the government itself is responsible. It actually tries to find out whether the individual is responsible. We have already seen who is this individual. He could be a commander in chief, he could be a policy maker in chief who basically suggested such kinds of war must be conducted, and after that, who takes the responsibility, even though that person directly does not say, I take the responsibility, but the commission understands that he should take the responsibility for planning, plotting, and executing war crimes. Also, as you get to see in the second paragraph, it should report to the government's concerned cases in which it appeared that adequate evidence might be expected to be forthcoming. Who is this government? It is the state in which that entire war crime has been committed, or it is the victim state against which the war crime has been committed. Very clearly, it means that the legitimate government is asked that there can be some evidences to come and support, or there can be some evidences to cooperate with the commission, war commission. Now comes the question of war crime trials. We have already seen these war crime trials. What is their responsibility? What is their duty? To figure out, to find out who was the individual, who was the main plotter, who was the main policy maker to execute the war. Now, the first one that we are going to study today is Nuremberg trial. Following World War II, the victorious Allied governments, that is the opposition of Germany and Axis party, this Allied government established the first international criminal tribunals to prosecute high-level political officials and military authorities for war crimes and other war crime atrocities. Again, you are getting to see it is not the government, but it is the individual political leaders who are going to be tried, because these individual political leaders basically came up with the idea that we want to attack some other states. So, this war commission, war tribunal, war trials, etc., make it very clear that the persons who have plotted, who have executed the war plans are not the entire country, because the entire country cannot be punished for a number of political leaders who decided that the wealth of the state, the manpower of the state will be used to attack other country, even if the particular manpower of the state did not want to go ahead with it. Therefore, what we do get to see, Allied governments established the first international criminal tribunals to prosecute high-level political officials and military authorities for war crimes and other wartime atrocities. Four major Allied powers, if you see from that time's perspective, France, Soviet Union, United Kingdom, and the United States. China is not mentioned here, and as you do understand, it is not Russia, but it is Soviet Union. Okay, they set up the International Military Tribunal in Nuremberg, Germany, to prosecute and punish the major war criminals of the European Axis. This is after Second World War, and in this Nuremberg trial, we will also to get to see how the Nazis, how Hitler and his party were tried. Now let's concentrate on Tokyo trial. Now we were discussing about European Axis trial, but now we will be shifting to Tokyo trial. So this is the lesser known International Military Tribunal, or IMT, for the Far East, was created in Tokyo, Japan, pursuant to a 1946 proclamation by US Army General Douglas MacArthur, Supreme Commander for the Allied powers in occupied Japan. The IMTFE presided over a series of trials of senior Japanese political and military leaders pursuant to its authority to try and punish Far Eastern war criminals. Again, we are not getting to see Japan as a whole was considered as the war criminals, but we are getting to see some political and military leaders of Japan who were considered as war criminals. Now let's again come back to Europe, Holocaust, and also Hitler's trial. So this one took place in 1960, as you do get to see almost after, like, 18 to 20 years after the like Second World War. So here it is known as Eichmann trial. In 1960, the major Holocaust perpetrator Adolf Eichmann, who is the namesake of Adolf Hitler also, was captured in Argentina and brought to Israel to stand trial. In 1961, the District Court of Jerusalem tried Adolf Eichmann on 15 separate counts, including crimes against Jewish people, because we do understand when we are talking about Holocaust, Jewish people were victimized. So, against the Jewish people, crimes against humanity, war crimes, and membership in a hostile organization, that means which did not want to resolve the conflicts in a peaceful manner. The trial, the first one in history to be videotaped, aroused interest worldwide, bringing Nazi atrocities to the forefront of world news and prompting international debates regarding legality of the trial. Obviously, this generated a lot of curiosity because this was the first trial, as it is stated here, that was videotaped, and because it was tried by a domestic court, the legality of such trial was questioned. So the court rejected the preliminary arguments raised concerning its own competence and jurisdiction in trying Eichmann, and after a trial lasting 8 months, found him guilty on all counts and sentenced him to death. He was executed by hanging on June 1, 1962. It means that Eichmann trial ended in the punishment conferred, that is the highest, and as from Indian side we say rarest of the rare punishment, but here it was understood because he has committed most heinous international criminal offense, he was given death punishment. As we do get to see here, his crimes committed against the Jews, which had been secondary to the Nuremberg trials. Next, we are going to discuss about some other criminal trials which were not connected with the European, war crimes or the Second World War war crimes, but these were in line. That means there was some impact on it, not only from the World War but also from the colonization, dominance of the Western countries, etc., and obviously of human rights violation. So the first one that we are going to discuss here is My Lai massacre and trial. So it was the mass murder of unnamed South Vietnamese citizen by United States troops in South District, South Vietnam on 16th of March 1968 during the Vietnam War. Between 347 to 504 unarmed people were killed by the US people, that is US military people. And in this, we do get to see, if you search in the internet, very disturbing contents will be coming up. Say, for example, the skulls of the people who were killed, or for example, the entire skeleton of the people, because these were all tried to be hidden, right? Following the massacre, a Pentagon task force called the Vietnam War Crimes Working Group investigated the alleged atrocities which were committed against South Vietnamese civilians by the US troops. The VWCWG also investigated over 500 additional alleged atrocities, but it could not actually verify them. Again, it was not against the US government, but it was against certain military personnel who actually took up the responsibility or took up the activities of creating the massacre. So the My Lai trial began on November 17, 1970. Military effectiveness depends on obedience to orders. Understanding this, the acts of subordinates done in compliance with unlawful order given to him by his superiors are excused and impose no criminal liability upon him unless the superior's order is one which a man of ordinary sense and understanding would under the circumstances know to be unlawful, or if the order in question is actually known to the accused to be unlawful. As we have already seen, military effectiveness can be executed through the subordinate officers. Subordinate officers will be taking the directions from their superiors, from their bosses, and therefore their liability comes to the grassroots level. And the highest liable person would be those persons who have basically commanded, or who have basically directed the grassroots level officers to execute that order. So the Army's Criminal Investigation Division continued its separate investigation. Most of the enlisted men who committed war crimes were no longer members of the military, because they had either retired or they had left, and thus they actually demanded for immunity from the prosecution by court martial. A 1955 Supreme Court decision, Toth versus Quarles, held that military courts cannot try former members of the armed services, no matter how intimate the connection between the offense and the concerns of the military discipline. Decisions were made to prosecute a total of 25 officers, enlisted men, including certain generals that you do get to see here. In the end, however, only few would be tried, and only one, that is William Talley, would be found guilty. After 13 days of deliberations, the longest in US court martial history, the jury returned its verdict guilty of premeditated murder on all specifications, and after hearing the pleas on the issue of punishment, jury head Colonel Clifford Ford pronounced Talley's sentence. So, as I was mentioning, that apart from the Rome Statute, there are other international instruments are also there. We have to give now consideration for Geneva Conventions. Whenever we are studying war crime, we must not forget about 4 Geneva Conventions. The first Geneva Convention, 1949, protects the wounded and the sick soldiers on land during the war. The second one protects, that is the same year 1949, protects the wounded, sick, and shipwrecked military personnel at sea during the war. Very briefly, the first convention has 64 articles. These provide protection for the wounded and sick, but also for medical, religious personnel, medical units, and medical transports. The convention also recognizes the distinctive emblems. Now, the same thing again has also been adopted by Article 8 and also other articles that address war crimes under Rome Statute. Second Geneva Convention, as I mentioned, is about the sick and wounded in the sea during the war. This has also been accepted by the Rome Statute. This basically prevented inhuman throwing of the bodies, that is the sick and wounded soldiers on the shipwrecked ships or on the warships, throwing their bodies in the water or in the sea water, and it made it mandatory for bringing the bodies to the shore and handing over the bodies with respect to the families. As we do get to see, this convention has 63 articles and replaced Hague Convention of 1907 for the adaptation to maritime warfare of the principles of the Geneva Convention. Next, we get to see the third Geneva Convention. As in the previous slide, we did get to see first and second Geneva Convention. The first convention addressing sick and wounded people in the land warfare, and the second Geneva Convention 1949 addressing sick and wounded people in the maritime warfare. So the third Geneva Convention 1949 applies to the prisoners of war. The convention replaced the Prisoners of War Convention of 1929. It contains 143 articles, and whereas we do get to see 1929 convention had only 97 conventions. The categories of persons entitled to prisoners of war status were broadened in accordance with the conventions, especially 1 and 2. The conditions and places of captivity were more precisely defined, particularly with regard to the labor of prisoners of war, their financial resources, the relief they received, and the judicial proceedings instituted against them. The convention establishes the principle that prisoners of war shall be released and repatriated without delay after the cessation of active hostilities. This convention has 5 annexes containing various model regulations and identity and other cards, which means that this convention enlarged the scope of the right of the prisoners, especially war prisoners, more than what the other conventions had. It basically considered right to defense, also right to self respect, right to not to be victims of custodial torture, etc., for the war prisoners. The fourth Geneva Convention 1949 is very important here, which protects the civilians, including those in occupied territories. Clearly, this is also within the meaning of war crime because it says even if the war is going on, the civilians who are not engaged in war but who are staying in the occupied territory or who are staying in the conflict zone must also be given certain kinds of protection, and the perpetrator state or the faulty states cannot go ahead for vandalizing the civilian properties, the civilians, etc., that we are getting to see in the recent war. The convention adopted in 1949 takes account of the experience of World War II. It is composed of 159 articles, contains short section concerning the general protection of the populations against certain consequences of war without addressing the conduct of hostilities as such, which was later examined in the additional protocols of 1977. The bulk of the convention deals with the status and treatment of protected persons, that means the civilians who are not in the war, distinguishing between the situation of foreigners on the territory of one of the parties to the conflict and that of the civilians in the occupied territory. All of us are aware that if there is any war or conflict now going on, the respective embassies first see that their citizens are protected. Exactly the same thing is actually being reflected in this convention. It spells out the obligations of the occupying power vis-a-vis civilian population and contains detailed provisions on humanitarian relief for populations in occupied territory. It also contains specific regime for the treatment of civilian internees. It has got 3 annexes containing a model agreement for hospitals and safety zones, model regulation on humanitarian relief and model cards, and Geneva Convention have been ratified by all states. This Geneva Convention 1949 is also reflected in the fourth category of the international criminal activities, that is criminal activities against humanity or criminal activities against civilians, that we have seen Rome Statute very clearly mentioned. Now comes a very pertinent question. Can Geneva Convention be applicable for non-international conflicts? That means, can Geneva Convention be applicable for civil war? We do get to see that such kinds of questions come up in the exam papers. Such kinds of questions arose even after the Rome Statute was created. So here we have to concentrate on Article 3 of the Geneva Convention, which is common to the 4 Geneva Conventions, that is Geneva Conventions 1949, marked a breakthrough as it covered for the first time situations for non-international armed conflicts. Obviously, yes, these types of conflicts actually vary. They include traditional civil wars, internal armed conflicts that spill over into other states, or internal conflicts in which third states or a multinational force intervenes alongside the government, which very clearly represents that yes, Geneva Convention can be applicable for non-international conflicts also, but such internal conflicts, internal armed conflicts, civil unrest must be of such a nature that it can reach to international conflict. That means such kinds of conflicts will start affecting the other states also, which were nowhere connected with this conflict. As you do get to see here, it requires humane treatment for all persons in enemy hands without any adverse distinction. Specifically, it aims to prohibit murder, mutilation, torture, cruel humiliations, and degrading treatment, and also for taking of hostages and unfair trials that basically are done by the perpetrating states. It also requires that wounded, sick, and shipwrecked to be collected, to be cared for, and if there is any dead body, this dead body should not be disrespected but to be flown back to the family with respect. It grants ICRC the right to offer its services to the parties in the conflict. It calls on the parties to the conflict to bring all or parts of the Geneva Convention into force through so-called special agreements, especially for the humanitarian, attacks, etc. It recognizes the application of these rules do not affect the legal status of the parties to the conflict. That means it actually respects the sovereignty of the country, but still then it tries to resolve the conflicts. And given the most armed conflicts today are non-international, applying Common Article 3 is the utmost importance, because we do get to see in most cases it is the civil unrest or it is the internal armed conflict that sprouts as international armed conflict. Therefore, Geneva Convention can be applicable to certain specific non-international armed conflict also. Now again, let's focus on the protocols to Geneva Convention and initiation of Red Cross. About Red Cross, most of us know, but the protocols that basically supported the Red Cross will also be uh, discussed here. So two protocols additional to the four 1949 Geneva Conventions were adopted in 1977, and they strengthen the protection of the victims of international and non-international armed conflicts, place limits on the way wars are fought. Protocol 2 especially was the first ever international treaty devoted exclusively to situations of non-international armed conflicts, which again goes back to the previous discussion, whereby we do get to see Geneva Convention may be considered as applicable convention for those which are non-international armed conflicts. In 2005, that means so many years after the Second World War, we do get to see a third additional protocol was adopted, creating an additional emblem to Red Cross, that is Red Crystal, which has the same international status as Red Cross, Red Crescent emblems, which all denote medical facilities, paramedical facilities to the wounded and sick persons in the war front. So now we are getting to see protocol additional to the Geneva Conventions of 12th August 1949 relating to the protection of victims of international armed conflicts. This was adopted in 8th June 1977. Article 1 subclause 4 provides that armed conflicts in which people are fighting against colonial domination, alien occupation, or a racist regime are to be considered as international conflicts. This has been very much applied in African continent and also in some Asian continents, where you did get to see such kinds of conflicts, especially against colonial domination or racist dominance. Part 2, Article 8 to 34 develops the rule of the first and second Geneva Conventions on wounded, sick, and shipwrecked victims. It extends the protection of the conventions to civil medical personnel, equipment, supplies, and to civilian units and transports, and contains detailed provisions on medical transportation. This protocol is still followed and it has got a long span of life. Part 3 of the several chapters deal with conduct of hostilities, that is, questions which hitherto were regulated by the Hague Convention of 1899 and 1907 and by customary international law. Their reaffirmation and development is important in view of the age of Hague Conventions and of the new states which had no part in their elaboration. Article 43 and 44 give a new definition of armed forces and combatants. Among the most important articles are those on the protection of the civilian population against the effects of hostilities. They contain a definition of military objectives, prohibition of attack on civilian persons and objects. Further, other articles also deal with the protection of civil defense organization, relief actions and the treatment of persons in the power of a party to a conflict, which means those organizations, those actors who go ahead for providing certain kinds of protection for the civilians during the conflict are also provided certain kinds of protection. Part 5 brings some new elements to the problems of execution of conventions and the protocols.
Thank you.